Hi, we're going to follow up on some previous comments I made in an earlier blog on jurisdiction issues, particularly regarding the Uniform Child Custody Jurisdiction and Enforcement Act, again the UCCJEA. This act governs the jurisdiction of a court to address issues of child custody, whether that be in a separate action or through a divorce. This particularly applies to military members and spouses because service members are often receiving orders to move between states, and this act, the UCCJA, provides some guidance for courts and parents on where cases regarding their children and divorce should be actually heard. Again, in general, a child custody matter must be heard in the child's home state. That is where the child in general has lived for the last 6 months prior to the filing of the action. There are some exceptions to this rule. First is a court of a state may have emergency temporary jurisdiction to make an order regarding child custody if the child's been abandoned or the child or the parent is in danger. But again, in this situation, the state court does not generally assume permanent or long-term jurisdiction. It's only a means for the judge in a state where the child actually is living at the time to make an order to make sure the child and the parent are safe. After that, the judge in that state and another state that may be the child's home state are going to have to discuss where the case should properly proceed. Another related question in this regard is courts do not have the authority, except in these emergency circumstances, to modify a child custody order made in another state. So for example, if a service member obtains a divorce in Texas and then it receives orders for California and moves to California, but the other parent, or perhaps the parent and child, stay behind, the service member in all likelihood cannot file a motion to modify the child custody order from Texas in California. Texas is the initial jurisdiction, the initial home state, and only in limited circumstances, for example, like this emergency situation, can California take authority over the case. Another possible means of changing the original jurisdiction of the original home state or the original order is if that initial state is an inconvenient forum. And so one way to address this is the forum is inconvenient, the initial state is inconvenient if neither parent nor the child lives there anymore. Again, for military members, the parties may have been divorced in a particular state. The member's orders send them somewhere else. The other spouse either follows along with those orders or goes to a different state entirely. In that case, neither parent nor child is in the original state. There's really no reason to keep it there. So then the question becomes, where should the new or a new motion be filed to address potential issues? But it's likely that the initial state will no longer keep that case because nobody involved is in that state anymore. And then the final question is a little less extreme than that, where you may address issues of inconvenient forum even if one of the parents continues to reside in the original state. So for example, The parties are divorced in Texas. The civilian spouse moves with the child by agreement to a different state, and the service member sees the child only once or twice a year. In that case, there's probably very little information about the child and the family at large in the initial state of Texas, even though the service member parent continues to live there. So it's very possible that the civilian parent could file a motion in another state where the child is living, 90–95% of the time, and claim that it is a more convenient forum because there just is not enough information or contact with the original state to allow the court to make a reasoned decision. There might not be many witnesses or evidence in the initial state anymore, even if the other parent still lives there. So those are some ways to potentially get around or address issues of jurisdiction under the UCCJEA. But as I've said before, these are fact-intensive questions. If the issue comes up for any military member or civilian spouse, speak to your lawyer, go through a detailed timeline of where everyone in the family has lived and for how long, and also what relations and ties each person may still have to a particular state. We talked about that in earlier blogs, such as driver's licenses and voting and paying taxes, etc. But these are fact-intensive questions, and you want to make sure that you start off on the right foot in any of your filings so that your situation goes as smoothly as possible. Talk to you soon.